Good morning, good afternoon, good evening to all the participants to this exciting webinar. My name is Francesco Sindico, and I am the co-chair of the IUCN World Commission on Environmental Law Climate Change Law Specialist Group. We are here together with not everybody, but a lot of people who have been part of IUCN's journey before the International Court of Justice Advisory Opinion. The speakers today include people like myself and Christina Voigt and Grethel Aguilar, who had the privilege of speaking to the court in December, but also everybody else on the panel, which I will shortly introduce, who are part of the core team led by Christina Voigt, the chair of the World Commission on Environmental Law, who worked tirelessly for over 2 years on the written proceedings to the International Court of Justice. We have the pleasure of being joined by Grethel Aguilar, the Director General of IUCN, who I will soon give the floor to, but also Anna Kantzelis, Corina Heri, Anna Kantzelis from Sixth Form Court, Corina Heri from Tilburg University, Caroline Foster from Auckland University, Margaret Young from University of Melbourne, Harro and Asselt from Cambridge University, Christina Voigt herself from the University of Oslo. We have Nilufer from the National University of Singapore, and also our fantastic colleagues who support the team, Marina Trindade and Roberto Coll. I don't really need to introduce a lot the advisory opinion. It's been almost a month. I now realize it's literally a month tomorrow, the first anniversary, if you want to call it like that, of this advisory opinion. A lot of ink has already been poured about it very quickly, I have to say, but I think it's good to have a month to just digest it a bit more and share some of our reflections. I have to say that although I wasn't there and Christina Voigt was there on behalf of IUCN, I was really impressed positively by it. And after a month and having read it a little bit more carefully, I'm still happy. I was a bit afraid that after a month I would have said, oh my gosh, I was too excited at the beginning. No, I am still quite happy about the outcome. So let me share how we're going to do this. There's so many speakers, so I did kindly ask them not to give formal presentations, but really to engage in a conversation with myself, but also with yourself as participants. After Grethel Aguilar will give a wider IUCN perspective to the proceedings and her own preliminary remarks, I'll give the floor to Christina Voigt, who will have a bit more time. It's a privilege of being the chair of WCEL and having spent more time on this than any of us, to really give her own thoughts about how the opinion went and to some extent how it has aligned or not with our own work at IUCN. After that, I'll have a conversation with several of our speakers where I will be focusing with them on specific aspects of the advisory opinion and on specific points that IUCN has made. With, again, a few of the speakers will then have a further conversation about, to some extent, the implications of all of this, speculating going forward what the impact of this advisory opinion may or may not be. All going well, we will have some time for questions. So I do kindly ask, you will see, as often happens in webinars, there's a Q&A opportunity in the box, a Q&A box. Feel free to use it. Feel free to pose your questions. Do address them to a specific speaker if that is the case. And if not, answers to all of us will also be absolutely fine. So without further ado, I will give the floor now to Grethel Aguilar, who I remind you is the Director General of IUCN. It's a massive privilege to have you with us, Grethel, and I give you the floor now.
Thank you very much, Francesco, and good morning, good afternoon, good night to all the ones connected around the world. It is an honor for me to be with all of you to celebrate a historic milestone for international law, for climate justice, and for the future of people and nature. As we all know, on the 23rd of July, 2025, the International Court of Justice advisory opinion confirming that states have a legal obligation to take all necessary measures to limit global warming to 1.5 degrees Celsius was adopted And this is the reason that we are here. This opinion is groundbreaking. And I am very happy, Francesco, that you're still happy being such an expert, because it draws upon the United Nations climate treaties, human rights law, the law of the sea, and customary international law. Importantly, it also affirms that the Convention on Biological Diversity informs climate obligations, and that a duty of cooperation applies to all states around the world. The court also provided clarity on the Paris Agreement. It is found that the content of the national determined contributions is not left to the discretion of states, but that each state must act with due diligence to reflect its highest possible ambition in every successive NDC as required by Article 4.3. And critically, it confirmed that implementing these NDCs is an obligation of conduct. This is a powerful affirmation that the climate crisis is not just a political challenge, but a matter of law and a matter of justice. The implications of this advisory opinion are profound. By clarifying that the states are legally bound to act with ambition and diligence, the court has reinforced that inaction or insufficient action on climate change is not simply a policy choice. It is a breach of international law. This shifts the landscape of accountability, empowering vulnerable communities, civil society, and international institutions to press for stronger commitments and providing courts, policymakers, and negotiators worldwide with a clear legal foundation to demand urgent science-based climate action. IUCN is proud to have contributed to this important process. Last year, IUCN presented its statement before the court in The Hague. Our submission stressed that climate change is not only a crisis of rising temperatures, but also a crisis for humanity and nature alike, with significant impact on ecosystems, species, and human rights. I want to acknowledge here the privilege of having personally testified before the court on behalf of IUCN, but more importantly, I want to express my deepest gratitude to all of those who made the moment possible. In particular, I want to thank the IUCN World Commission on Environmental Law, under the leadership, the amazing leadership of Professor Christina Voigt, and the incredible technical support of Francesco Sindico. I know that their tireless dedication, expertise, and vision have been instrumental in shaping IUCN contribution to these historic proceedings. I also want to thank all of you, many of you that are going to speak today, and many of you who are participating in this webinar for your contributions. IUCN is nothing without the commissions. And the commission, the World Commission on Environmental Law, has done this incredible piece of work that has positioned IUCN in this space that we have not been before. Just last year, we participated in 3 international court procedures, and this is a big step for IUCN. And Christina, I want to acknowledge your energy, your knowledge, and your wisdom to take IUCN to these lands. So thank you very much. This advisory opinion is more than a legal milestone. It is a call to action. It underscores the strong legal frameworks. The strong legal frameworks are essential tools for hope, accountability, and transformation. They can anchor ambition, drive cooperation, and help us secure a just and sustainable future for all of us and for nature. IUCN's unique role, bringing together science, law, and policy, has once again proven vital in shaping the global response to the twin crises of climate change and biodiversity loss. Our mission now is to build on this moment, ensuring that the court's message translates into accelerated, concrete action on the ground. colleagues, friends, this is not only a matter of obligation, it is a matter of survival, solidarity, and most importantly, justice. Let us use this moment to strengthen our resolve, to raise ambition, and to act decisively for our collective future. I wish you a fantastic webinar, as all the webinars that the WCEL is putting together, has been putting together during this year. And once more, let me express my deepest thank you to all of you. I cannot see the number of people connected, but I imagine that you have many around the world. Some wake up very early, some are very late at night. And I appreciate everybody's time, because only together as a union, we can achieve the planet that we want. And I'm sure that IUCN nowadays, with everything that is happening, needs to play this role. And this is a good example of the things that we can do. Thank you very much for the opportunity.
Thank you very much, Grethel, in particular also for the kind words for myself, Christina, and all the team. It's been a pleasure having you also at the heart of this and accompany me and Christina in The Hague in December. So I'd like to now move on quickly to giving the floor to Christina, but let me remind you first, this is, as Grethel said, this is a World Commission on Environmental Law webinar. It's part of a wider series, The Transformation of Environmental Law. And it is being recorded. So for any of your colleagues, friends on the other side of the world, where it is way too late to be up, I definitely hope nobody's woke up for this. Please let your friends, especially from Latin America and that side of the world, that they can see this webinar recorded later. But I will give now the floor to Christina, really to take us on a journey on how she feels the advisory opinion worked out and the extent to which it does reflect the work that IUCN and the WCL in particular has put into it. So I'll give you the floor, Christina.
Thank you so much, Francesco. Thank you for bringing us together here today. And I would like to start with a very warm welcome to everyone who is joining us. I see we have currently 168 participants. The number is still going up. So it is apparently meeting quite a lot of interest. And as Francesco said, it will be recorded and available on the WCL website for everyone to watch it who is not able to join us here today. Many thanks also for the speakers who join us, but I'll say a little bit more about the speakers in a moment. I would like to start by thanking Dr. Grethel Aguilar, who just spoke before me, not just for her very kind words of recognition of the work of the World Commission on Environmental Law, but I also would like to thank you, Grethel, for the confidence and the trust that you put in the World Commission on Environmental Law and our team in representing the IUCN, the International Union for Conservation of Nature, before the International Court of Justice and the other two courts, the International Tribunal Law de Sea and the Inter-American Court on Human Rights. It's not a given. It is something that is building on a cooperative relationship between the commissions and the IUCN Secretariat, and I just wanted to thank you for that confidence. I also want to thank you for your personal involvement in the oral hearings before the court in December. It was an amazing moment for all of us, and your participation and your statement was absolutely crucial. Many thanks as well to the fantastic, wonderful WCL Dream Team. There is nothing better I can say, or there is no superlative that I cannot use in describing this team. It's been a wonderful endeavor to work together with all of you. And as Francesco said, it was a long time coming. We worked for, I think, more than 2 years on the written statements, preparing the oral statements, preparing the answers to the questions that came from the judges, and we only had a week before Christmas. But we do see, and I'll come back to that much, if not anything, everything that IUCN put forward was picked up by the court in one way or the other. So thank you for the time that you put in, for the demanding tasks that you fulfilled, for the short deadlines that you had to comply with at awkward hours for some of you. I'm just thinking of our colleagues in the Antipodes, New Zealand and Australia, Caroline and Margaret, who many times had to participate at hours deep in the dark night. And that all, please let me underline this, on a pro bono basis for all of us. And to you, Francesco, my partner in crime in this endeavor, it was an absolute joy and privilege working with you, pulling together the team, bringing together all these different important expert voices, coordinating our inputs, holding to timelines. And it was you, Francesco, who started it all, basically saying, why don't we ask the court to authorize IUCN? Let me draft a letter. And we did not know how that would go. What would the court say to the letter from the IUCN asking to be authorized to participate in the proceedings? And we did get a positive response, and that's where it all started. So thank you so much, every one of you, Francesco in particular, for this joint journey. You did an outstanding job. And as we now know, by the almost 100% alignment between the IUCN statements, the written statements, and the oral statement, and the court's opinion. We will hear more about this through our webinar today, but I dare say there is perhaps no other participating state or international organization that can claim this, that can claim that it was so well aligned with what finally the court stated. And this bears witness to IUCN's recognition as an institution that can provide sound legal arguments, sound legal analysis based on sound science. And the speakers today, as Francesco mentioned, will dig a little bit deeper in the particular aspects that they prepared in IUCN's submission. Yes, it was an amazing experience for IUCN, for the World Commission on Environmental Law, for our team to be part of this endeavor. As I said, we participated in all 3 climate change advisory proceedings, but it was the first time that IUCN appeared before the ICJ. And as Grethel said earlier, to stand in front of the court, to stand in front of the ICJ in the Great Hall of Justice, and to speak on the protection of a common good, of our planet and its people and nature for present and future generation, is an impressive experience. And so was it to sit there and listen when the president of the ICJ read the advisory opinion. I think for everyone who works in this field, in international law, in climate change law, and climate change issues and nature protection, this is a highlight that will never be forgotten, I guess, by any one of us. Now that we have the advisory opinion, and as Francesco said, much has already been said and written about it, I would like to just highlight, what did I say, 7 brief aspects which aspects of the opinion which I think are particularly relevant and worthwhile to dig into, and we will hear a bit more detail about this throughout the webinar. To start with, a friend of mine, Justice Bharati from the Supreme Court of India, said upon the issuing of the advisory opinion that with this opinion, the ICJ really became the world court. And I think he really struck a chord there by what we've now heard, by everyone pretty much supportive and happy, as Francesco, about what the court says. Now, let me just briefly get through those 7 elements that I think are worthwhile shedding some light to it, but there are many, many more that I will not go into it. First of all, I think it's fair to say that the advisory opinion marks a new era for the court itself. The court had never said anything about climate change, and now coming forward with an opinion which is so detailed and progressive and thorough is a new era for the court. And it's a new era for international law in general and for international environmental law and climate change in particular. As we know, it was the largest proceeding ever held before the ICJ. Never said anything on climate change before, but it also was for many states, for many small island states, the first time ever that they appeared before the court, which it all makes it historic. And it's astounding that the court delivered such a progressive, diligent, and detailed opinion, not shying away from addressing some very contentious issues in diplomatic relations and international discourses, which otherwise are highly politicized. And here the court diligently looked at it through the lens of law. The second point, yes, the advisory opinion is per se not legally binding, but the obligations are. The obligations that the court highlighted and identified are binding. Otherwise, there wouldn't be obligations. So that's very important to highlight. And it does carry significant normative weight. Partly it was coming, or the request was coming from the United Nations General Assembly, also based on a consensus-based resolution. And the opinion was adopted unanimously. There was no dissent by any of the judges on any of the main points that the court found. And it will have to go back to the United Nations General Assembly, who requested it, to see what's going to make out of it. But moreover, I think, and many I think share this view, the opinion will have effect on other courts, either international courts or domestic courts, who have been involved in many climate proceedings, as you all know, and who were kind of cross-fertilized, referring to other decisions by other domestic courts. So in addition to that horizontal cross-fertilization, we now have the possibility to have a vertical cross-fertilization where domestic courts will look, and we already seen examples of that, will look at what came from the international level, from the International Court of Justice, ICLOS, in informing their domestic decisions in domestic courts. And I'm sure it will have effect on diplomatic processes as well as domestic legislative processes, changing the domestic legal framework. And it will reflect, and we can discuss this towards the end, how it will be taken up in the UN climate negotiations now around the corner in November in Belém at COP30. And I do also think that it will have effect on the constituted bodies under the Paris Agreement, who will most likely look at what came out from Hague in their processes further. My third point here goes to the core finding. What are the most important thing that the court said? And I think, and here you may have different opinions, but in my opinion, the most important aspect is that states have the obligation under international law to do the utmost to reduce greenhouse gas emissions, to protect sinks and reservoirs through nature-based solutions. And they have these obligations based on several independent, parallel, and mutually supportive legal sources. These are the UN climate treaties, human rights treaties, the law of the sea, CBD, and other international treaties, as well as customary international law. None of these is lex specialis, and all of them apply in parallel. So wherever you look now in international law, basically, there is a legal obligation to reduce greenhouse gas emissions and to act with stringent due diligence. I think this is a very important finding, which also enhances the consistency and harmony in international law, because the court also applied similar standards in terms of what states need to do to achieve the 1.5 degree goal of the Paris Agreement throughout or across the entire spectrum of international legal sources. And very important, breach of any of these obligations can constitute what's called an internationally wrongful act and give rise to state responsibility with the consequences of, for example, reparation, of course, which includes, for example, also compensation. So this is one of the core findings that the court put forward. To get into a little bit more detail on the different legal sources, I think the next element that I'd like to highlight is that the court, as the first and so far only international court, undertook a detailed interpretation of the Paris Agreement. It was expected that the court would do so, but it wasn't quite clear to what extent it would go into the nitty-gritty details of the Paris Agreement, given that the interventions before the court went into all sorts of directions. And as you all know, the Paris Agreement was negotiated in a very difficult political setting. It took long negotiation hours, and much of the text is marked by significant ambiguity. But the court didn't shy away from looking at the text, interpreting it in the light of the object and purpose of the Paris Agreement, as well as the Framework Convention on Climate Change. And it found that the obligation to prepare, communicate, and maintain nationally determined contributions is an obligation of result. That's not new. That's something we knew already, especially if you work for the Paris Agreement Compliance Committee. That's clear. That's an obligation of result. And we also know that more than 170 states have not put forward that result this year, and that enabled the Compliance Committee to act. But I'll come back to that a little bit later. But in addition to that, as Grethel already indicated, and I think that's a very important finding, it clarified that the NDCs do not, or the content of the NDCs does not fall entirely within the discretion of states. Many states wanted to have it this way, and many interventions before the court would point to the nationally determined nature of NDCs, and that whatever parties write in the NDCs is completely in their discretion, and it's voluntary. And the court said, no, it isn't. It is a legal obligation of conduct that you put forward NDCs that align with the 1.5 degree target, that are progressive every time they're being put forward, and that are reflective of each state's highest possible ambition, as well as being informed by the outcome of the global stocktake, which, by the way, mentions transitioning away from fossil fuels. And that all needs to be done with stringent due diligence. So I think this in particular is a very important finding, and maybe the one that can have a very immediate impact, because we're still waiting for many NDCs to be put forward. And finally, on the NDCs and the courts delving into the Paris Agreement, it also found that parties have an obligation of conduct to implement and achieve their NDCs. And if you know the negotiation history of the Paris Agreement, this was again one of the very controversial aspects, whether it's actually something that parties need to do under the Paris Agreement. And the court said, yet, and again, with stringent due diligence, you have to have domestic measures that are able to implement and achieve the NDC. So this is important. These were contentious issues in the negotiations and adopted with much ambiguity, and now clearly defined by the court. The next point, as we will hear a bit more about later by Corey, is that the obligations are also based on human rights treaties. I will not go into much detail here. The IUCN put forward very detailed arguments before the court as a positive obligations to take all necessary measures to protect, preserve, and respect human rights. And also these are informed by international standards. And here the court went even further in this context, also recognized the human right to a clean, healthy, and sustainable environment as a condition for the enjoyment of other human rights. This was one of the questions put forward by one of the judges, and IUCN prepared a particular response right before Christmas. Corey turned around and used her time to send it through the IUCN submission to the court, and we believe that it did have an impact on what the court found in the end. The next point is, of course, the importance with respect to obligations under the Law of the Sea Convention, UNCLOS. In this context, and we will hear more from Nilufer, the court followed quite strictly the findings by the International Tribunal on the Law of the Sea in its advisory opinion from May last year on greenhouse gas emissions constituting pollution of the marine environment, and that again opening the obligations to address pollution of the marine environment and protect and preserve the marine environment based on stringent due diligence. It is very important that the court followed ITLOS, the International Tribunal of the Law of the Seas approach, not just in order not to establish a different standard, but also as a matter to create harmony and consistency in international law, where we have two international courts who basically underline the same legal finding. The next point is that crucially, very crucially, the court found that the customary rule to prevent significant harm to the territory of other states and to areas beyond national jurisdiction, the no harm rule, is applicable to the protection of the climate system. That's something that IUCN put squarely forward to the court. We spent a lot of time analyzing this rule. Caroline will speak about it in more detail a little bit later. And we were extremely pleased to hear the court confirming that the no harm rule is applicable to the climate system. And that applies to all states, right? As a customary international rule, it is something that applies to all states. And the court went further, saying that also has erga omnes character. It is based on a stringent due diligence standard, and even more interesting for maybe international lawyers and hopefully also decision makers is that the court set up a detailed list of what it means to comply with that requirement of stringent due diligence. This includes the adoption of necessary measures to be informed by science and technology, best standards, to take into account relevant international rules and standards, to apply a certain differentiation depending on the capabilities of states, to act with precaution, to have a risk assessment and environmental impact assessment, and to carry out notification and consultation. So this details the core content of acting with stringent due diligence in the context of prohibition of significant transboundary harm. So here the court really gives a detailed legal toolbox to everyone working on this field. Second to last, the court also highlighted that the secondary international legal tool of state responsibility applies, even if the climate treaties and other treaties do not identify legal consequences of breach. We have the concept of state responsibility, which applies to breaches of international law that amount to internationally wrongful acts. And if you listened to Francesco's 5 impactful minutes of interventions at the very last speaker before the court, he detailed this in great precision to the judges. The court also said, of course, the consequences apply, restoration, which includes restitution, compensation, and satisfaction, in addition to the cessation of the wrongful act and guarantees of non-repetition. But the details need to be seen in concreto, in the context of specific cases, and it cannot be defined in abstracto. And this is exactly also what IUCN had argued in front of the court. One last thing, which I think also Nilufer will talk about, is something that IUCN did not put to the court. So that's maybe the only thing where we did not go as far as the court did, and that is the court statement with respect to sea level rise. That was, of course, of very important importance to the initiating constituencies of the advisory opinion, in particular Vanuatu and many small island states that took the initiative and put it forward to the General Assembly and then to the court. The court found the continuity of statehood, even if constituting elements of statehood like territory or people or functioning government should appear as an effect of sea level rise. That does not impact on the statehood per se. The state remains, even if some of these elements disappear. This has been widely discussed element, and the court here followed the International Law Commission's position on subscribing to the rule of continuity. And second, that states have no obligation to update and revise their charts if baselines may change due to the impact of sea level rise. That is also a very important finding because it preserves the marine entitlements in the marine zones for island states and coastal states, even if sea level should change the baselines. So this is very important, and as I said, except for that last element, all of the other elements that the court put in its advisory opinion reflect what IUCN had argued in front of the court. And I do recommend to either go to our written submissions or just listen to our oral intervention before the court to see how well it in the end aligned. Yes, it is an impressive and far-reaching opinion. Much needs to be unpacked and assessed, and as we will hear today by our wonderful colleagues. But most importantly, it now needs to be implemented, right, to show impact. So it doesn't remain a paper tiger coming from The Hague, but actually shows impact in terms of emission reductions and nature protection all over the world, and to be acted upon. And I think the next steps will be clear. We have the United Nations General Assembly meeting in September in New York, where the General Assembly needs to, deal with what it got back from its request to The Hague. We'll see how this goes. Of course, we have the IUCN World Conservation Congress in October, where the advisory opinion will be a big topic. And then also COP30 and the Brazilian presidency has already showed very significant interest in what exactly the court said. So we can expect that this will also feature in one way or the other in the negotiations in Brazil, but also, of course, much beyond in many places, domestically and internationally. So with that, I thank for your indulgence, and thank you, Francesco, for giving me the time to share my views, and I'm happy to give the floor back to you.
Thank you very much, Christina. That just goes to show how rich the advisory opinion was, and will be, hopefully, going forward in terms of the impact. Now, let me start a conversation where I will ask specific members of our, as you said, fantastic team, just to indulge a little bit more on specific aspects of the advisory opinion that reflect, in a way, what they have been mostly working on in the advisory opinion. Although we did work as a team, some people focus more on some areas and some on others. I'm going to start this conversation with Caroline Foster. Caroline was, as Christina said, instrumental in leading our efforts in relation to customer international law. So my question to you, Caroline, is, now that we have the advisory opinion in front of ourselves, how do you reflect on what came out? Are you happy with the outcome related to customer international law? Do you think it will have an impact? What are your thoughts on the customer international law dimension of the advisory opinion? And one thing, sorry, Caroline, I do see some questions popping up. We will try to answer them, but if any of our speakers do want to engage with them as well in the chat, in the Q&A, feel free to do them, and then we can expand, provided we have some time. But Caroline, what do you think about customer international law and the advisory opinion?
Thanks, Francesco. It was an excellent advisory opinion on the custom front. I do think one of the fascinating things is the way in which even within the customary international law, the Paris Agreement or any successor there might be to it is still very, very central. So the court is really encouraging the international community to lean into the existing treaty regime. So for the states who are party, most of the states in the world, of course, the court goes so far, you'll remember, to suggest that at the present stage, compliance in good faith with the climate change treaties suggests that they're substantially complying with their customary international law duties. But the court's still clear that its comments don't mean that customary obligations will be fulfilled simply by complying with the treaties. And then if you think about the non-party states, the court also says, well, any non-party state that cooperates with the states party to the 3 climate change treaties in a way that's equivalent to that of a state party, well, they will, in certain circumstances, they may be considered to fulfill their customary obligations. So it'll be fascinating to see what might come of that. But the other, I suppose, general point is that the court's work on custom really also enhances the advisory opinion's enduring quality. There is a bigger picture to the point where the court indicates we don't know if or when, but there could be a time when further treaty-based obligations are needed with the increased urgency of the climate crisis. And the customary international law obligations that the court outlined constituted, in the view of the court, a legal standard for assessing whether, if the climate change treaties through time during the crisis that we are heading into will actually continue fully to serve their purpose.
Yeah. And maybe just a follow-up question. You mentioned the non-party dimension of customer international law. That, for both scholars and practitioners, that is really almost the magic of customer international law. I mean, how did you interpret that? I mean, was it in a way a wink to specific countries that have not been too sympathetic to the Paris Agreement? Or is it just something that courts will always say because that's what customer international law is about? It applies to all states of the international community.
Oh, quite so. Customer international law does apply to all states. But this was a little bit special. I don't know that I've seen an international court make this specific point before, or this suggestion of a way to go about complying with customary international law through doing things that fit in with a treaty that virtually all the other states are party to. So it's a little bit special. One of the really interesting additional comments you probably saw from the court was it suggested that a non-party state that was not cooperating in the manner envisaged would have, the court said, the full burden of demonstrating that its policies and practices are in compliance with its customary international law obligations. It's an open question what the court might have been alluding to by burden, whether there is any hint there of some kind of possible reversal of the adjudicatory burden of proof or the basis on which that might rest. But it was a fascinating comment as well. That might just mean politically, who knows?
Thank you very much, Caroline. And I will now move on from New Zealand to Australia, to the University of Melbourne. And I have a question for our colleague, Margaret Young. The advisory opinion also engaged with other multilateral environmental agreements and other treaties, not just the Paris Agreement. One of them being, for example, CBD and so forth. What has been your opinion? What is your reflection on how the court engaged with biodiversity-related international treaties, but also the way they interact with both the Paris Agreement, but also with customary international law.
Thank you, Francesco. And it is great to be back with the Dream Team. When you mentioned that, I thought, well, I was often working when I should have been dreaming, given I was here in Australia, but I'm sure you're actually referring to our credentials, Christina, with that comment. And it is really good to see you all. So Francesco, yes, the court was remarkably systemic in its treatment of the obligations of states under international law to ensure the protection of the climate system. And this was consistent with IUCN's advocacy about the scientific conceptions of the climate system, which includes not only the atmosphere, the hydrosphere, and the geosphere, but also, crucially, the biosphere. And as a result of this framing, obligations of states to protect the climate system are found in multiple sources, as discussed by Christina and Caroline. So not just the UNFCCC and the Paris Agreement. I was delighted by the court's discussion of the directly relevant applicable law, starting, of course, with the UN Charter. I should note that I've been working with some designers here at the Melbourne Law School and the University of Melbourne to visualise the approach of the court in bringing together the climate treaties alongside the Convention on Biological Diversity, the Desertification Convention, the UN Convention on the Law of the Sea, and international human rights law. These are the spheres you see behind me in my Zoom backdrop. So we're trying to capture the significance for states holding these obligations, so where they are party to these different treaties. And of course, when one looks at customary duties, the ones Caroline has outlined, which by definition bind all states in this system, the way the court has interpreted customary obligations by reference to a systemic view of treaty obligations is very consequential. So I'm happy to make comments about the techniques used by the court, including through treaty interpretation according to the general rule in the Vienna Convention on the Law of Treaties. Perhaps I'll talk more about that in Q&A if there's time, but I want to focus now on implications for biodiversity related agreements, Francesco, as you've asked me to do. So IUCN has been very careful to include a range of biodiversity-related treaties in submissions, including the Convention on Biological Diversity and the Kunming-Montreal Global Biodiversity Framework, and the new agreement on marine biodiversity beyond national jurisdiction, the BBNJ agreement, which, although not having entered into force, was recognised by the court as having relevant objectives about the resilience of biological diversity to climate change. I'm very gratified that the court has engaged carefully with these treaties and that it also refers to the remedy of restitution as including the restoration of ecosystems and biodiversity. So this is part of the legal consequences if states are found to have caused significant harm to the climate system with their acts and omissions. So more could be said about the systemic reasoning with respect to legal consequences, which Christina has already taken us to in part. So let me go back to the question of obligations. So in providing us with this comprehensive understanding of state obligations, the court acknowledges that ecosystem protection measures may simultaneously operate as climate change mitigation or adaptation measures. This is supportive of IUCN's submissions about nature-based solutions, about which the IUCN has a lot of expertise. Of course, Francisco, this is not to say all obligations exist consistently or harmoniously, and an important point in the context of the fragmentation and diversification of international law that many of us work on is indeed that sometimes obligations do not cohere. The court emphasises that states parties to environmental treaties must take their obligations under these environmental treaties into account when implementing their obligations under the climate change treaties. So this is in the passage which notes that environmental treaties, climate change treaties, and relevant obligations under customary international law inform each other. Now, this view of the court accords with IUCN's submissions, and it is relevant, I think, to our advocacy about the need to minimize negative and foster positive impacts of climate change on biodiversity. Thanks.
Thank you very much, Margaret. Just to emphasize one or two points before we move on. I also found it quite interesting how, and I'll say this in an elegant way, the court almost seemed to copy-paste some of its sections when it said that it had to be mutually supportive and interpret each other. It did it with the multilateral environmental agreements, it did it with the law of the sea, it did it with human rights. So clearly there was an emphasis on these cannot be read in isolation, they have to be read together. The restitution, in terms of actual practical application on how to restore ecosystems, that is huge for IUCN. And I think that's an aspect that within IUCN, we really want to dig into and look at the practical implications that can be absolutely huge, also from an adaptation perspective. So thank you very much, Margaret. We could spend all day talking about this, but I do want to move on and now focus more on law of the sea aspects. And here we had the pleasure to have in the team Nilufer Oral, who's obviously a great expert in this field. And my question to you, Nilufer, is there's a reason to some extent why the International Tribunal for the Law of the Sea rendered its advisory opinion before the ICJ. Now, clearly that wasn't in the mindset of the court, of the tribunal. It was on those who brought the case before the Tribunal of the Law of the Sea. But I feel that the sequence worked really well, but that's my opinion. I'd like to hear from you, Nilufer. From your perspective, has the ICJ worked well with ITLOS in a way? Has the ITLOS advisory opinion been reflected in the proper way in the ICJ advisory opinion? I give you the floor, Nilufer.
Yeah, thank you, Francesco. Yeah, good question. And you're right, I'm actually a member of the legal team of the Commission on Small Island States that brought that first advisory opinion. And that certainly was one of the issues, is the timing of it. And I think it did work out very well because, first of all, that advisory opinion was quite narrower. Obviously, the opinion request that went before the court was quite broad. So ITLOS, which also, may I highlight, was also a unanimous opinion. So we're dealing with unanimous opinions, which in and of itself is a rarity. And I think only highlighting just how serious climate change is being taken at the very highest judicial levels. So I think it did, and ITLOS again. I have to say, no one knew what at that time the tribunal's opinion would be. And I feel we have relived that moment with the court as well. Like, okay, what will the court say? What will ITLOS say? And now ITLOS is even bigger. You have more judges, on ITLOS. So that was a unanimous opinion, very robust as well. And now the next, big anticipation question, okay, how will the court address the law of the sea issues? How much will it defer to ITLOS? And as we know, one of the themes in international law has been the fragmentation. And early on when ITLOS was established, there were some, even on the court, who were a bit skeptical. But I have to say, this opinion to me shows a very important evolution and progress on international law. We're looking at the big picture as well, beyond just law of the sea. And the court, and I tried to count, but pretty well close to 40 times, the court cited ITLOS. And not only did it cite it, and I have to say, this is the part I really I like to repeat because it's so important that, and I'm going to quote, give me a little time, I know I only have a few minutes, but the court observes, and this is in paragraph 338, the court observes in this regard, since its establishment, ITLOS has developed a considerable body of jurisprudence on UNCLOS, both in contentious and advisory proceedings. although the court is not obliged in the exercise of its judicial functions to model its own interpretation of UNCLOS on that of ITLAS, right, saying, hey, we're independent. It considers that insofar as it is called upon to interpret the convention, it should ascribe great weight to the interpretation adopted by the tribunal. So it basically, in the opinion, and I think Christina brought that out, it was basically, well, ITLA said this, definition of pollution, citing ITLA's, greenhouse gas emissions constitute pollution. And we know this was so critical part of that original opinion. Due diligence, the stringent due diligence. And I have to say this also, the theme is, yes, IUCN also said this. And we very clearly in our written statement to the court aligned ourselves very closely with ITLAS, and so did the court, basically. So the court also adopted the perspective of the very stringent due diligence requirements, and also that meeting the obligations under the UNFCCC in Paris would not be enough for UNCLOS, and this was a very important part of the ITLAS opinion. So I can say that even though it wasn't intended or planned that way, the sequential aspect in relation at least to the law of the sea turned out to be an excellent one. And now it's quite clear from the court that issues relating to the law of the sea belong with ITLAS in relation to at least climate change. Maritime boundaries, no, but that will always still go to the ICJ, I think.
Thank you very much, Nilufer. And even that may be affected by, let's call it the obiter dicta on maritime and small island developing states that Christina just mentioned. But thank you so much, Nilufer. It's a privilege to see your perspective, both from one court and the other. Moving on, there's another aspect of this advisory opinion which was very much anticipated. And I think it got even more anticipated because just a few weeks before the Inter-American Court of Human Rights rendered its own advisory opinion, which obviously was focused very much on human rights. So here we had the privilege of working with Corina Heri, now at Tilburg University. And as Christina said, Corina was one of those colleagues who had to work hard before the Christmas break because the judges were very interested in some questions, which interestingly, they literally refer to in their advisory opinion. I thought that was really interesting to see that that work that week actually made an impact, as Christina said. And the question to you, Corina, is relatively straightforward, very difficult to answer, but relatively straightforward is, do you feel that the human right to a clean environment has been strengthened or not now that we have the advisory opinion? So I give you the floor, Corina.
Thank you so much for this question and also for the space to talk about these topics with all of you and also hear from you all. I would love to say yes in response to your question. And that's because the court does acknowledge the right to a healthy environment. It does acknowledge the fact that this right's been widely recognized. It connects it with other rights that can be impacted by climate change, like the rights to life and health. And all of that aligns with IUCN's submissions. So that's certainly important and positive and not something to be taken for granted. But if we're talking about strengthening the rights specifically, there's some caveats that we need to talk about. So the way the opinion approaches the right to a healthy environment is quite interesting. So it says, for example, the right to a healthy environment is, quote, a precondition for the enjoyment of many human rights. Then it says, quote, it's inherent in the enjoyment of other human rights. And then it says it's essential for the enjoyment of other human rights. So that feels a little repetitive, almost like it's trying to hit the right formulation. And what's interesting in that is what the court's not saying, because when we compare this to other parts of the opinion, which are so revolutionary, it feels like the court was holding back a little bit here. Now, I don't want to underplay the importance of the court's findings, of course not. The court recognizes that the right to a healthy environment exists, and it certainly does exist. in regional, international, domestic systems. This right's been recognized. But the question was, what does it mean for the obligations of states on the international level? And does it create any additional binding obligations beyond other human rights? And the court is quite silent on that point. So it doesn't explicitly establish whether, and this goes to Caroline's point, whether this is a norm of customary international law. And it doesn't explain what the content of this right might be. We saw several of the judges in their declarations and separate opinions being quite divided about what the court's actually done here. Now, we could speculate about the reasons for this. Maybe the reason is that some states don't yet recognize the right to a healthy environment. Maybe it's because there's different approaches to this right across different systems. Judge Clady, in his separate opinion, argues that the court held back too much on recognizing this right as a customary norm, and he actually says the bar for recognizing norms of customary international law has been lower elsewhere, so he doesn't understand why it was set so high here. But if I read this, I think what the court's trying to do is leave space for the specialized human rights bodies to do their work. So it's issuing an invitation for more engagement with human rights by other bodies, which I think is very good news for all of us, because this right is potentially highly transformative. We've seen that, for example, in the Inter-American system, where we've seen that it recognizes that it requires mitigation measures, it protects nature, it enshrines principles of equity, and it was even recognized as a norm of jus cogens. Now, if I can just say one more thing before my time
Absolutely.
is over.
Yes. Sure.
If I have to think about what we take away from this, I think it's very good news that the ICJ made it clear that human rights law is relevant here. It's not displaced by other obligations, and it's part of this wider tapestry of obligations that states have in the context of climate change, within which the right to a healthy environment is particularly important. But what the court's done is not explain what all those obligations are, but open the door for more engagement with human rights law by these specialized bodies in ways that are harmonized with climate and international climate treaties. So I think what this is a beginning and a signal that more engagement is needed, which I think is very good news.
Thank you very much, Corina. And think, again, having had the Inter-American Court of Human Rights just a few weeks before was an interesting comparison. And I take your points that potentially could have gone maybe a bit more, but also let's think that it could also have done the opposite. So in a way, I see it as good news. Before we move to our last part of this conversation, one thing I will say is that it did say, at least the way I read it, is that the court also limited itself to, for example, the sectors of international law it looked at, partly because of the question itself. And I do think, and I remember the reference to Marpol, for example, that it made it very clear that we can actually find climate obligations elsewhere as well. And I think this is actually powerful. It's almost like the advisory opinion starts the journey. And this just goes to the heart of climate change being a systemic issue that touches every single aspect of society, every single aspect of our lives. And I'll get back to that at the end. But in a way linked to this, and this is my question for Harro van Asselt from Cambridge University, who also was a fantastic member of the team. Because I think, and I don't know, Christina was in the room, so maybe Christina and Nilufer can tell me, but at least from my side, one of the biggest gasps when I listened to the advisory opinion was when the court actually referred several times to fossil fuels. That's really when I said, wow, this is big, guys. This we really need to stop and think about it. So my question to Harro is, what has been your perspective on that? Did you have a big gasp like me? What does your gasp mean in relation to the production of fossil fuels?
Right. Thanks, Francesco. It may not sound very academic, but I punched the air when it happened. But thanks also for asking the question. And it's great to be reunited with the IUCN team here. But let me start with the responding to your question with referring briefly back to the science. And in a way, this is also what made me punch in the air, because it is so important. Because we know now from IPCC reports, from reports by the International Energy Agency, from reports by the UN Environment Programme, that to keep below 1.5 degrees means no new fossil fuel production, and also planning for drastically phasing down fossil fuels. And even though in the climate negotiations, we had a call for transitioning away from fossil fuels in the global stocktake outcome a few years ago, some states in the proceedings, including some major fossil fuel producers, argued that there are no legal obligations pertaining specifically to fossil fuels. Other states, on the other hand, argued that not only are there such obligations, they also already have been breached. Now, against this background, I think there are 5 important points that have implications in the court's advisory opinion pertaining to fossil fuels. First, at the very beginning, it includes fossil fuel production in the relevant state conduct for the purposes of the advisory proceedings. I think that's already set a marker for what the court would say next. And second, even though it doesn't mention fossil fuels in this context specifically, I do think that its unequivocal embrace of the 1.5 degree goal, a link to best available science, also suggests, referring to the reports that I mentioned, that parties must at the very least not expand fossil fuels. Then third, as Christina already mentioned, the court suggests that parties do not have unfettered discretion in developing their NDCs and in developing their associated domestic measures. And the court doesn't elaborate much on that, but Judges Bandari and Cleveland do so in their joint declaration, where they spell out that the obligations on Article 4, paragraph 2 of the Paris Agreement require that states, NDCs, address all fossil fuel production, licensing, and subsidy activities in a manner consistent with achieving the 1.5 degrees temperature goal. Again, a very clear signal. Then fourth, the court suggests in its advisory opinion both that the customary obligations, both related to environmental impact assessments, as well as notification and consultation, also apply to major fossil fuel projects. Again, also something that we called for in our reply to Judge Cleveland's question at the end of the proceedings. And then last, but certainly not least, the court also made a statement that fossil fuel production, subsidization, and licensing may constitute internationally wrongful acts that can ultimately lead to legal consequences, including cessation and other consequences. Now, if I can, let me share a few cross-cutting reflections on what the court said and maybe also what it hasn't said. First, I think in a way what you're saying already now, Francesco, it's very telling that the court chose to single out fossil fuels. We don't hear the court talking about deforestation or industrial activities, but it did feel called upon to make explicit pronouncements on climate change mitigation and fossil fuels. And this is particularly important given that in the context of the climate negotiations for almost 3 decades, we have hardly seen parties really move this issue forward. Yes, I mentioned the transitioning away from fossil fuels, but that really was the most what parties have done in over 3 decades of negotiations. So I think already this is very telling. Second, and related to that, I don't think these points would have been made if it hadn't been for some countries, particularly Vanuatu, consistently raising the linkage between fossil fuel activities and climate change. And I think that thanks to Vanuatu, as well as to other climate vulnerable states, we can see the emergence of a quite sophisticated legal debate on states' obligations in this area, not just in the advisory opinion, but also in the written proceedings. Third, maybe in line with Corina, of course, one could always want for more, right? Like, so of course, the court doesn't say everything what one might have hoped to see, even though acknowledging that the court has broken new ground. The court, for example, does not link fossil fuel production to potential human rights violations, as we did in our submission and as Vanuatu also did in its submission. It also doesn't talk about the role of international economic law, which it kind of bracketed altogether for the purposes of the advisory opinion. Again, I would have loved to see more in this space, but I can also understand why the court didn't do so. And then as a final point, to the extent that we will see contentious litigation emerging at the international level, something we'll probably talk about in a second, I anticipate that it would focus on countries that are expanding fossil fuel production whilst at the same time claiming to be climate leaders. I don't need to name the countries. You can probably figure out who they are. But I do think it will matter in this regard. I also think it will matter at the domestic level, and it provides fuel, excuse the pun, for domestic litigants seeking to challenge new fossil fuel developments. So I'll stop there and then hand it back over to you.
Thank you very much, Harro. And yes, I agree with you that it's very telling that for many decades, even just the word fossil fuels was almost banned or very difficult to include in any COP decision or any negotiation process. And I think that's what really stood out, that they could have mentioned so many other things to some extent in the advisor's opinion, but they did focus on it. I think when you after a month, you realize that it's not that fossil fuels is present in every single paragraph of the advisory opinion. You do realize that it's, it's almost like reading between the leaves of tea or whatever the word in English is. But nevertheless, it is very, very powerful. So thank you to all our speakers that have participated in this more specific conversation. I do see there are many, many questions coming in, and I do apologize if we won't have much time to discuss them, because I first want to go back to Christina and to Anna Kantzelis to focus a little bit more on the and now what are the implications. To Christina in particular, and I do kindly ask you, Christina, to keep it as brief as possible, in relation to Paris. You did mention in your presentation, in your talk, about COP30 coming up. I would also suggest COP31. I think we're not that far away to some extent from the COP in Australia / SIDS Pacific. How do you see this impacting, influencing? Is it just going to be a beautiful side event that an amazing organization may or may not organize, or is it actually going to be something more substantial? So I'll let you, Christina, jump on that, and then I'll ask Anna another question about the future impact of it. Christina.
Yeah, I was almost inclined to say give Anna the word first, but you asked me, I keep it short. I'll say a couple of words about the COP, but the COP is the global gathering for a global conversation about the future steps under the climate regime. But I think where the findings by the court on NDC content and domestic measures, also with regard to fossil fuels, as Howard just mentioned, really matter is in domestic processes, right? In the preparation of the NDCs. And it's not a one-time off. We all know that this is going to happen again and again and again, like every 5 years. And that periodicity is really important because it is something that will come back and hit states again and again and again. So I think that is where it really matters. And it's a tool for stakeholders, for civil society, for parliamentarians, for everyone involved or should be involved in designing the nationally determined contributions to really put pressure and use the advisory opinion for all it's worth to ramp up ambition domestically, because that's where it matters and that's where it needs to be implemented. How it reflects in the COP, we don't know yet, but I think the discussion around NDCs and NDC content hasn't really been part of the negotiations, right? Except for Article 4 in Paris and the ambition mitigation work program, which hasn't really led to much detail. This is a changing moment. It's really something where the discussion changes towards looking in more detail on what actually needs to go into the NDCs. So I think this is going to be interesting to see how it's first reflected in Brazil, COP30. I would expect maybe some, I don't know what we're going to get, like a cover decision again or some place to collect all these different elements that are currently flying around, but some recognition and welcoming, hopefully, of the ICJ advisory opinion by all parties should be a minimum. And from there, we may see flowing some more detail informing the negotiations. And then, of course, we still have many parties, as I already said, that have not submitted their NDC, which was due on the 10th of February this year. That was the deadline set by the Conference of the Parties. They haven't done so. They all received a letter from the Paris Agreement Compliance Committee, and we will have a meeting again in a couple of weeks from now to see what has happened since. But it is, of course, a big invitation and ask to those parties who have not yet done so to really reflect on what the court said in the still outstanding submission of their NDCs. And as I said, and then every 5 years from now on. I think that's where the power really lies. And maybe that's also where the most immediate impact of the opinion may be found. Thanks, Francesco. Back to you.
Thank you very much, Christina. And I do think that fact that so many countries have not submitted their NDC, but now you have the advisory opinion that says that the NDCs are not just procedural, is not just at their discretion. I wonder whether there's some nervousness in those who have to submit it to realize, oops, maybe I have to update it in a slightly different way. If that were the case, that would show the impact of the advisory opinion. It will be interesting to review carefully what comes out of the NDCs. Thank you, Christina. So Anna Kantzelis from Sixth Bomb Court in London. Anna was also instrumental, especially in the latter part of our work at IUCN. And my question to you is a bit broader, is how do you see this impacting both at domestic and international level, global efforts, but also individual efforts in relation to climate change?
Thanks very much, Francesco. In the final paragraph of the advisory opinion, the judges actually note that international law has an important but ultimately limited role in resolving climate change. And they say that they hope that their conclusions will allow the law to inform and guide further social and political action. So in practice, as colleagues have already noted, the opinion's effect is going to turn on how states and others use it individually and collectively within other international and national frameworks. And that reflects how international law gives form to and limits to power. I'm going to identify 4 contexts in which I think the opinion can and probably will be used at the international level, and then 2 at the domestic level. This is a non-exhaustive list, and many of the conclusions I'm going to put forward have already been alluded to by colleagues. So I'll go through them very quickly so we don't labor over points that have already been made. So internationally, as Christina just noted, it should significantly strengthen diplomatic leverage and ambition ahead of the upcoming meeting of the UN General Assembly in September and COP30 in November. The opinion has anchored collective ambition under the climate treaty regime to the 1.5-degree goal and clarified really stringent obligations in connected with NDCs. So the implication then is very clear. States have to do more than they're doing currently. And that gives campaigners and governments firmer legal ground to press for stronger action through the multilateral process. Second, the opinion affirms customary duties that cut against unilateral backsliding and that strengthen multilateral frameworks. So the duties to prevent significant transboundary harm and to cooperate apply to all states, including non-parties to climate treaties. Withdrawing from a treaty then does not remove those obligations, and that reduces incentives to exit cooperative regimes and undercuts unilateral threats, which we've seen, of retaliation against states engaging in net zero or other cooperative frameworks. It's clear that international law requires good faith cooperation from states in the context of climate change. Third, the opinion confirms that international litigation remains a credible complement to diplomacy and keeps accountability pathways open before international courts and tribunals. We know that legal accountability can be pursued not only before the ICJ, but where appropriate before the ITLOS and regional or UN human rights mechanisms. And we now know with more detail on what basis those claims might succeed. This clarity can concentrate minds within the climate negotiations while preserving lawful recourse if cooperation falters. Fourth, the opinion sends some interesting signals and opportunities for institutional reform and interpretive alignment of obligations across different areas of law that may be taken up by some states and campaigners in the near to medium term. So, for example, Judge Bandari suggests in a separate declaration that the General Assembly should consider establishing a claims commission for climate harms. It's an interesting suggestion and comes at a time when there's also growing state interest in establishing an international environment court as part of wider environmental governance reforms. I note that Judge Cleveland also in a separate declaration argues that investment treaty law should be interpreted in light of states' climate obligations, pointing toward treaty-consistent readings that reduce chilling effects on regulation and may influence future arbitral practice. And then extremely briefly, just at the domestic level, the opinion provides a firm legal basis for demanding more stringent domestic climate regulation and enables governments to present that to their citizens as a legal obligation rather than a political choice. So in the UK, for example, where I live and work, the opinion has already been referred to in debates on North Sea fossil fuel licensing, with the argument being made that permitting new projects would increase the risk of the UK breaching its international obligations. And then finally, the language and standards in the advisory opinion are likely to filter through into domestic climate litigation and judicial review. So although they won't be directly binding, the advisory opinion will have indirect effects, and it supplies persuasive benchmarks for what international law requires of states. Just a final word to wrap up on strategic considerations, though. So I've just outlined how the opinion might be used. Judgments about how and when to invoke it constructively, though, will differ and will need to be made in the current political context. Trust in multilateral institutions is declining. Climate policy is increasingly polarized. Electoral cycles are reshaping incentives at the domestic level, and internationally, energy security narratives are becoming more salient. We know that fiscal constraints and cost of living pressures are also complicating choices when it comes to the implementation of climate policies, and geopolitical rivalry right now is affecting cooperation and supply chains. So that's all to say that there's both opportunity and some risk in how the opinion is ultimately leveraged. Poorly handled diplomacy or legal threats could provoke backlash, chilling ambitious statements or commitments at future COPs. And some states might also reduce transparency to avoid perceived litigation exposure. As pointed out by Judge Nolte in his separate declaration, there are also practical limits to what contentious litigation might deliver. And therefore, I think the opinion's greatest utility may ultimately be in the diplomatic and regulatory spheres if used constructively, but we'll wait and see. And thank you very much for having me, and great to see everyone today.
Thank you very much, Anna. And thanks to all of you for your very insightful comments. We are getting close to the end. We only have roughly 10 minutes. What we're going to do now, rather than answering 17, if not more questions, which I'm delighted to see, and I'm thinking a way that we will not just leave them there and not deal with them. So as both the Climate Change Law Specialist Group, the WCEL as a whole, will try to gather them and deal with them in a proper way. And we know how to get back to you participants. So we will try to get back with some answers. But I'm trying to identify a question that can be answered by all of us and that can almost be used by our speakers as one last opportunity to say a few words about it. And it goes to some extent along the lines of what Anna was just saying. And it is our first question. I'm not doing this because it's easier. I just think it's actually does work. And I just kindly ask all of you, Margaret, Caroline, etc., to just look at the first question, which is how should the international community, and more especially UN agencies, incorporate the advice of the ICJ into their daily work? And I would almost go as far as extending not just international communities and UN agencies. You choose any actor of society. If you work in a university, even your university, or private sector, or whatever you would like to answer. But take this as an opportunity for a few last comments, some reflections on, now we have this advisory opinion, we have to make it work. What does that even mean? So happy to get anybody to volunteer to go first, but Caroline, perfect, thanks. And then Anna.
Thanks, Francesco. I have to take the future generations angle on this, one of my favourite topics, and also an important aspect of the court's decision. I mean, quite simply, the court says that the principle of intergenerational equity requires due regard for the interests of future generations. So that can be employed in a very wide range of institutional contexts. And the court is also specific about how to do that. That these interests need to be taken into account, and they couch this in terms of states, but I'm sure that it applies everywhere because it is a principle. These interests need to be taken into account when making decisions and implementing policies in fulfillment of obligations under treaty and customary international law.
Thank you, Caroline. I think Anna wanted to go next.
Yeah, thank you so much. I think the point that I want to draw out is I, like Harro, was punching the air when I was reading this out. I was very excited by it. And I think very many international lawyers and colleagues of mine are similarly excited by the richness and breadth of this decision. But then I think as lawyers, we also have a special responsibility to help non-specialists understand the concrete and practical implications of what is in here, because that's not easy for a non-specialist audience to get across. And I think there's a bridging role that we need to do in helping people to understand the relevance of this for their work.
Thank you, Anna. Absolutely. The complexity of this for a non-legal audience is something, and I know, Anna, you and I have spoken a lot about this, is absolutely crucial. And IUCN as well has a role in this. I think Harro wants to go next.
All right. Thanks, Francesco. Also, maybe just to reiterate some of the responses that I put in the Q&A on the private sector. The court actually doesn't say that much about the private sector and about business actors in its advisory opinion, particularly if you compare it to the Inter-American Court a few weeks earlier. I do think there's a few things. So the court at least gives a strong hint that due diligence requires states also to regulate private actors effectively. That's at least one thing. The other thing I think is more between the lines. So one of them is, I think, the 1.5 degree goal. So the fact that the court put that on a pedestal, basically said this is this is the main direction of travel. I think that will have ripple effects in business communities well beyond, let's say, regulation. This will also affect private standard setting in all kinds of ways. Second, I think also what I said about fossil fuels will put fossil fuel companies on notice, will put state-owned enterprises involved with fossil fuel production on notice. So again, there I think companies will have will pay heed to this. And third, also when the court's pronouncement on transboundary environmental impact assessment, anyone starting a new project that is likely to lead to greenhouse gas emissions, whether it's within their own country or in another territory, will again need to pay attention to this, because states might be held responsible for not carrying out these impact assessments.
Thank you so much, Harro. Give the floor to Margaret, then Corina, and then I'll give the last opportunity to Christina before I wrap up with my own conclusions. Margaret.
Yeah, thank you. I thought that was a great question, and I wanted to draw more on the institutional context of an advisory opinion to remind listeners about how these can have lasting impacts. I mean, the Chagos advisory opinion had lasting impacts for the General Assembly in its follow-up work, which then was taken up by ITLOS in one of its judgments, and subsequently by the UK in its domestic activities. We also had the Western Sahara case, a long ago case, advisory opinion that had a marked impact on Australia's whole legal system when one of our decisions of our highest court took it. So these are not just words. They exist in the work that we do. And I'd say also that legal academics have a real role to play, particularly in giving, I think, credit to Vanuatu and the Pacific states that took such action, you know, such a grand diplomatic effort to get this this opinion before the court. I think we need to teach and work with this material, not just in specific areas of international law, but across the corpus of public international law, and also for our domestic lawyers. There's so much in this, in both public and private law, that needs to be continued in the work that we do. Thanks.
Thank you, Margaret. Corina?
Thank you so much. I would just underscore how much has happened in the last 5 years in this context, where it's now become impossible to ignore the relevance and the applicability of international law, including human rights law. And like Margaret just said, these are not just words, they're obligations that are going to lead to more legal action. What exactly that looks like, which fora litigation by individuals or by states happens in, we'll have to see, but this is definitely not going away. And I think we're really standing at the beginning of the next wave of climate-related litigation. That's going to be very exciting to see. So I think more to come would be my takeaway.
And last but definitely not least, Christina, some final reflections from yourself before I draw my own conclusions.
I just wanted to point to the very last paragraph of the advisory opinion, which we haven't talked about, but I've seen a lot of reflections around it. And I think this is a very profound statement that the judges give us, everyone, every state, every international organization, every non-state actor, every individual on our way to address climate change. Not only does it qualify climate change as an existential problem of planetary proportions that impacts or imperils all forms of life on our planet, but it also says that international law is only part of the solution and a limited part. There have been needs to be, you know, accompanied and joined by other endeavors, all fields of human knowledge, whether law, science, economics, and any other in the view of the court. And finally, it says, above all, a lasting and satisfactory solution requires human will and wisdom at the individual, social, and political levels to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come, speaking to the intergenerational aspect that Caroline mentioned. I think these are profound words that the court chose very carefully to indicate this is upon us all, everyone, every individual. And I think breaking this down, what does it mean to do the utmost? What does it mean to act with stringent due diligence? Breaking this down in our respective professions, we use the law, others use economics, politics, diplomacy, and so forth, is absolutely important, because this is an all hands on board challenge, as the court identifies. And we need to reach out also to other disciplines and try to work together to find this comprehensive solution which the court demands. I think these are my last words. And before giving back the floor to you, Francesco, just one more time, thank you to every one of you who is here today and the members of our team who were not able to join us today, because it was a massive collective effort of all of us for such a long time, and we are deeply indebted to your contributions and time and knowledge. So thank you so much. Back to you, Francesco.
So thank you very much, Christina. We are running a little bit over the hour and a half that was scheduled, but I do kindly ask participants if they can stay just for a few more minutes. I just want to wrap up. As you all know, international lawyers, we do like lists. We like, 5 points, 3 points, 5 points. I am just like Christina. I also like points, like Harro. So I'm going to give you my 5 concluding remarks, let's say. Some are very personal, other are more linked to also the opinion itself. The first is, we have to remember that we could have gotten a very different opinion. And working towards the opinion, we have seen very clearly massive division between those who said one thing, those who said the other thing. The Paris Agreement is nothing, it's useless, blah, blah, blah. Customer international law doesn't exist in this aspect. The court could have gone slightly more in that direction. And that, in my opinion, would have been a disaster. So actually, just the fact that the advisory opinion did not take a shortcut, did not take the easy way out, let's say, that many countries were advocating for, that per se is something to remember very carefully. It could have been very different. The second point, and I think Harro mentioned it, the 1.5 degrees. This is huge. This is huge. There is no doubt, at least the way I read it, that the temperature goal now in law is now 1.5 degrees. And I think I absolutely agree with Harro. This can have ripple effects both in public and private sector. Third takes me back to the joyous moments when the Paris Agreement was adopted in Paris 10 years ago. I remember paragraph 51 of the COP decision that accompanied it about loss and damage, that some people can interpret like, yeah, well, whatever it says, do not then go after me for loss and damage. There's no liability here. And I remember the representative, I think it was Ecuador, who stood up very late at night and said, whatever that paragraph says, general international law still applies. And I say that as my third point because I think after this advisory opinion, it is very clear that the two work together and that there is, at least in principle, grounds for international responsibility and everything we said. Most parties, including ourselves, did not expand too much on that part, but the court did a good job. It was almost like walking on eggshells or whatever you want to call it, but it came out quite well, I think. A lot of it is, we're giving you the legal framework, go sort out the details later on kind of thing, which has its risks, and some judges mentioned it in their separate opinions and so forth. But I do think it is very clear, as my third point, that there is an aspect of international responsibility, and many countries were completely against that. The fourth is, and I'm happy a lot of you mentioned the last paragraph. I found the last paragraph really important for a number of reasons. It highlights that all of this is of a systemic nature. By systemic, I mean that this is a self-inflicted challenge. Climate change is made by us. Us meaning society, us meaning the economic system that most of us in the world are following. The fact that the court reminded this, and the fact that the court said law is not the ultimate solution, so a humble approach to law, which I very much favor, is something I wish to emphasize very much. But the fact that it is systemic does beg questions, as many of you mentioned, about public and private sector. Private sector doesn't just magically operate in the world. It operates because it's authorized by public sector as well, although there are many nuances to that. It will inevitably, like Corina said, lead to more litigation. Let's not see litigation as the nail in the coffin of multilateralism and cooperation. No, it has to go hand in hand, and it has to support each other. It's not going to be easy, but it will happen. There's nothing. I speculate that there will be more and more litigation in that sense. The fifth and last thing with which I finish the webinar is to remind ourselves how all of this started. And this started because of a dream of young people. And I do think that we do need to acknowledge that without that dream, we would have never been in this webinar, we would have never had the advisory opinion and so forth. Now, the dream got very complex. There was a lot of support, there was a lot of campaigning, there was a lot of all sort of things around it. But really, it all started in a classroom from young people. And it just, to me, reminds me, and I think it's important to remind yourself in 2025, when you turn on the news and there's, let's be honest, often very bad news, that dreaming is still possible, and that young people still can empower nations, can empower solutions, and so forth. So I'll finish with that. I would like to thank all our excellent speakers. An opportunity for me to thank Christina in particular to allow me to join her in this incredible adventure, if you want to call it like that. Interestingly, we thought the road had finished, and then now we see that there's potentially another advisory opinion coming up from the African Court of Human Rights. So maybe the journey has not completely finished for IUCN in this realm. But it has been a pleasure, and the whole team, again, on a pro bono and hugely demanding schedules and lives that we all have, the fact that we've done, I would say, a good job is fantastic. And again, thanks to all the participants from all over the world who have joined us. I do apologize for not having given the opportunity to actually pose the questions to the speakers, but the timing did not really allow it. But we will try to collect them and get back to you with them. Do join us for future webinars, both of WCEL as a whole, but also the various specialist groups. And for those of you who will be joining us in Abu Dhabi at the World Conservation Congress, please do come and find both myself and Christina will definitely be there. There may be others of us. And if you are coming to COP30 or surroundings, let's say, WCEL will also have a big presence there. I'll stop here. Thank you very, very much. And let's hope that the impact of the advisory opinion will be long lasting. Bye-bye.